Hi, I'm Noah Weisberg.
And I'm Garrett Horrocks.
Welcome to Holland Estates. You're listening to episode number 556. How are you, Garrett?
Oh, I'm doing well, Noah. How are you?
I'm doing well, thank you. Today we're going to talk about Benjamin orders. It's a remedy that is available to trustees. I think it's often overlooked in the context of estate administration, but it's a helpful remedy that estate trustees should keep in mind when they have difficulty locating the whereabouts of beneficiaries. So the case we're going to talk about today is Steele and Smith. And for our viewers and listeners out there, that can be found on Canley at 2018 ONSC 4601. So briefly, Garrett, why don't we go over the facts and we can talk about the application of the Benjamin order and what exactly a Benjamin order is.
Sure. So this was a very straightforward fact scenario. So the testator in this case died, leaving a will that provided an equal share of the residue of her estate to each of her three brothers, provided they survived her. In the event that one of the brothers or any of the brothers predeceased, that share would have otherwise passed to two of the testator's nieces.
Right. So one of the brothers, William, who is a residuary beneficiary of a portion of 60%, cannot be found. So the estate trustee seeks a Benjamin order from the court, which is essentially seeking that the beneficiary have predeceased for the purpose of distributing the estate. So the estate trustee brings the application. The public guardian trustee is served and proposes that the money be paid into court while the estate trustee inquire as to the whereabouts of the missing beneficiary. Now, I think we have to draw an important distinction between this case and instances of absentee and applications under the declaration of death, is because in this case, the facts seem to suggest that the concern of the estate trustee wasn't that the beneficiary had passed away, but that he was missing.
There was a finding of fact in the case that the estate trustee had gone to some significant lengths to try and locate this missing third beneficiary. I believe the estate trustee had reached out to a distant cousin or a distant relative to try and inquire as to his whereabouts, and the cousin was not able to assist and in fact declined to provide any information. So the assumption of the estate trustee is that this brother, for lack of a better term, didn't want to be found.
Right. The estate trustee had contacted family members, done online searches, and even employed a UK tracing company to try to locate this missing beneficiary. The court ended up granting the Benjamin order, and the estate was administered as if the beneficiary had predeceased. So, as we kind of mentioned earlier on, really the goal, the purpose of such an order is to protect the trustee in his administration of the estate. Now, obviously, there remains the opportunity that the beneficiary resurface, but the beneficiary would not be able to seek any claims or monetary remuneration from the estate trustee. The beneficiary would be stuck having to go after the recipient of the funds.
Right. And it's also important to keep in mind that this is not necessarily an easy order to obtain. The court is going to consider a number of factors which were set out in the cases, or the order's namesake, the Neville and Benjamin decision, which was a UK decision. So the court will consider how long has passed since the death of the testator, what steps the estate trustee or any other third parties have taken to try and locate the beneficiary, who conducted these inquiries, what kind of qualifications they had, and do the inquiries consider all of the evidence. So the court weighed all of those factors in this case and found that the estate trustee had essentially met their obligation, and the court granted the Benjamin order.
Yeah, and so again, just to summarize, generally useful for an estate trustee to know about the existence of a Benjamin order when they're administering the estate. In this fact scenario, it did not appear that a declaration regarding death or absenteeism was appropriate in the circumstances, and so the judge made the Benjamin order accordingly. So it's a short decision. I think the court quite succinctly sets out the law and the factors that they're going to consider before granting the order. And again, just an important option that state trustees should consider in their administration. So I guess, Garrett, that concludes our podcast. Until next time, we want to thank you for listening. I'm Noah Weisberg.
And I'm Garrett Horrocks.
Should you have any questions, please email us at webmaster@hollandhall.com or leave a comment on our blog. Thanks, Garrett.
Thanks, Noah.